Go. Hello everyone. This is Ricky, and what I'm about to share with you today is something that until about 72 hours ago was still under seal. The Supreme Court of the United States has issued what can only be described as an ultimatum to Donald Trump. Not a suggestion, not a recommendation, an ultimatum. And the language used in the order is unlike anything we've seen directed at a former president in modern history. Comply or face imprisonment. Those aren't my words. That's the essence of what's contained in a sealed directive that was partially declassified late Sunday night. What this reveals changes everything. Before we go further, I need you to subscribe right now, because what you're about to hear is not being explained clearly anywhere else, and you need to understand exactly what's happening while it's still unfolding. Let me start with the document itself. This is a judicial order signed by 6 justices. It's dated 11 days ago, but it only became partially visible to the public after a procedural filing forced a redacted version into the docket. The core issue is this: Trump has been ordered to surrender materials that he has repeatedly claimed do not exist. And the court has now said in writing that they have independent confirmation that these materials do exist, that Trump has access to them, and that his continued refusal to produce them constitutes contempt. Now, let me read this word for word because the phrasing matters. Quote, "The respondent is hereby directed to produce all documents, recordings, and communications related to the matters specified in subpoena 118A, no later than 14 days from the issuance of this order. Failure to comply will result in referral to the United States Marshal Service for enforcement, including custodial detention pending compliance." End quote. Read that again. Custodial detention pending compliance. That's not a fine. That's not a civil penalty. That's jail. And it's not punitive. It's coercive. Meaning, he stays there until he hands over what they're asking for. Now you might be wondering, what exactly are they asking for? The subpoena referenced in the order, subpoena 118A, was issued in connection with an ongoing matter tied to the January 6th investigation. But it's not about the events of that day, it's about what happened in the 72 hours before. Specifically, it demands communications between Trump and a list of individuals whose names are redacted in every version of the document that's been made public. But we know from adjacent filings that at least 3 of those individuals were senior military officials, another was a sitting member of Congress, and 2 others were private citizens with no official role. Here's where it gets worse. Attached to the subpoena was a declaration from a career archivist at the National Archives. That archivist states under penalty of perjury that the archives became aware of the existence of certain recordings in late 2024 after a security review of materials transferred from the White House Situation Room. The recordings were not logged in any of the usual systems. They were on a standalone device that was discovered in a storage box that had been mislabeled. The archivist describes the recordings as, quote, "conversations of substantial legal and historical significance involving the former president and multiple unidentified parties discussing contingency measures in the event of certification proceedings." Now, Trump's legal team has argued that no such recordings exist. They filed a motion claiming the archivist was mistaken, that the device in question was inoperable, and that even if it did contain recordings, they would be privileged. But the Supreme Court didn't buy it. In a footnote on page 9 of the order, the court notes that independent forensic analysis confirmed the device was functional, that the recordings are intact, and that privilege claims are, quote, "not applicable in circumstances involving potential obstruction of constitutional processes." Let me break that down. The court is saying that even if these recordings were originally privileged, that protection is void if they show an attempt to interfere with the certification of the election. That's a huge legal determination, and it's not coming from a district judge. It's coming from the Supreme Court. Now, I want you to think about the timeline here. This device was found in November of last year. That's 14 months ago. The archives notified the Department of Justice in December. DOJ opened an inquiry. A grand jury was convened in February of last year. Subpoenas went out in April. Trump's lawyers fought them. It went to the DC Circuit. Then it went to the Supreme Court. And now, after more than a year of litigation, the court has issued this order. That tells you 2 things. First, they believe the recordings are real. And second, they believe what's on them is critical. But it gets worse. There's a second document that surfaced at the same time. This one is a letter from the Solicitor General's office to the clerk of the Supreme Court. It's marked confidential litigation use only, but a copy was accidentally included in a public filing related to a different case. The letter was written 3 weeks ago, and it references a sealed hearing that took place in chambers with all 9 justices present. According to the letter, the hearing was convened because Trump's legal team had requested an emergency stay of the subpoena enforcement. They argued that compliance would cause irreparable harm to Trump personally and politically. The Solicitor General's letter summarizes the government's response, and here's the key line, Quote, "The government presented testimony from 2 witnesses with direct knowledge of the recordings in question. Both witnesses confirmed that the former president is aware of the recordings, has had access to them, and has discussed their contents with advisors as recently as 8 months ago." End quote. Think about that. Not only do the recordings exist, but Trump has listened to them. He knows what's on them, and he's been talking about them with his lawyers. Now, the letter doesn't name the 2 witnesses, but it does say they testified under oath and that their testimony was corroborated by, quote, electronic records, including metadata, text messages, and calendar entries. So, this isn't speculation. The government has proof that Trump knows exactly what they're asking for. Let me read you another section. This is from page 3 of the Solicitor General's letter. Quote, "One witness testified that the former president stated in the presence of at least 4 individuals that the recordings would be a problem if anyone actually heard them. The witness further testified that the former president directed that the device be kept in a secure location and that no copies be made." End quote. Now, stop and think about what that means. Trump allegedly told people that the recordings would be a problem. Not that they didn't exist, not that they were misunderstood, that they would be a problem if heard. That's consciousness of guilt. And then he allegedly ordered that they be hidden. Here's the part no one expected. The Solicitor General's letter also references a photograph. The photo was submitted as an exhibit during the sealed hearing. It shows a small digital recorder sitting on a desk. The desk is in an office that has been identified through background details as being inside Mar-a-Lago. The photo is time-stamped. The date is June 18th of last year. The time is 3:47 p.m. And according to the letter, the photo was taken by one of the witnesses who later testified before the grand jury. Now, Trump's lawyers have claimed the photo is misleading, that it doesn't prove the device contains the recordings in question, and that it could have been taken in any office at any time. But the Solicitor General points out that the timestamp matches security logs showing that the witness was in fact at Mar-a-Lago on that date, and that phone records placed Trump in the same building at the same time. You see where this is going? The government has testimonial evidence, documentary evidence, photographic evidence, and corroboration from metadata. And Trump's response has been to deny, delay, and defy. Now let's talk about what happens next. The Supreme Court's order gives Trump 14 days. That deadline is now 9 days away. If he does not produce the recordings by then, the order authorizes the U.S. Marshals to take him into custody, not arrest. Custody. There's a legal difference. This would be a civil contempt action, not a criminal charge. But the practical effect is the same. He would be detained. And according to the order, he would remain detained until he complies. Now, Trump's legal team has already signaled that they will fight this. They filed an emergency motion asking for an extension and arguing that enforcement would violate his rights under the 4th and 5th Amendments. But here's the problem. The Supreme Court has already ruled on those arguments. They rejected them, and the order makes clear that further delays will not be tolerated. In fact, there's a line on page 12 that I want to read to you. Quote, "This court has been patient. The respondent has been afforded every procedural protection. Further obstruction will be met with the full enforcement powers available to this court." End quote. That is not the language of a court that's open to negotiation. That's the language of a court that has reached the end of its patience. Let me give you some context. In the history of the U.S. Supreme Court, there have been very few cases where the court has directly ordered the detention of an individual for contempt. It's an extraordinary remedy. It's usually reserved for situations where someone is actively obstructing justice or defying a direct court order in a way that threatens the integrity of the legal system. The fact that the court is even considering this tells you how serious they believe the situation is. Now, let's talk about what's on those recordings, because that's the question everyone wants answered. We don't know the full contents, but we do know from the subpoena and from adjacent court filings that the government believes the recordings contain discussions about preventing or disrupting the certification of the electoral vote. We also know that the government has described the recordings as including, quote, explicit discussions of constitutional authority, the role of the vice president, and potential actions in the event of a disputed certification. Now, I'm not going to speculate about what specific words were used, but I will tell you this. If the government is willing to go to the Supreme Court, and if the Supreme Court is willing to issue an order like this, then whatever is on those recordings is significant enough to potentially change the legal landscape around January 6th. Let me also point out something that hasn't gotten enough attention. The subpoena doesn't just ask for the recordings. It also asks for all communications related to the recordings. That means emails, text messages, memos, notes, anything that references them or discusses them. And according to the Solicitor General's letter, Trump has not produced any of that either, which means he's not just withholding the recordings, he's withholding an entire category of evidence. Now, here's where it gets even more complicated. There are reports, and I want to be clear, these are not confirmed, but there are reports that at least one of the individuals on those recordings has already cooperated with investigators. This person has allegedly provided a summary of what was said, who was present, and what decisions were made. If that's true, then the government doesn't need the recordings to know what's on them. They already know. What they need is the recordings themselves, because audio evidence is far more powerful than a witness summary. You can't cross-examine a recording. You can't impeach it. It is what it is. And if Trump is refusing to produce recordings that the government already knows about, then the only reason to refuse is because hearing them would be damaging. Not just politically, legally. Let me tell you what this reveals. It reveals a pattern. Not just in this case, but in every legal battle Trump has been involved in over the past 3 years. Documents at Mar-a-Lago, testimony before the January 6th committee, financial records in New York, Georgia election interference. Every single time, the strategy has been the same. Deny, delay, defy, claim privilege, claim immunity, claim executive authority, claim prosecutorial bias. And when all of that fails, just refuse to comply and dare someone to enforce it. But here's the thing. The Supreme Court is not a prosecutor. It's not a political opponent. It's not the media. It's the highest court in the land. And when the Supreme Court issues an order, there is no higher authority to appeal to. This is the end of the line. Now, think about the politics of this. The Supreme Court has a conservative majority. 3 of the justices were appointed by Trump himself. And yet 6 justices signed this order. That means at least 3 of the conservative justices voted to enforce the subpoena and authorize detention if necessary. That tells you that this is not a partisan issue, this is a legal issue, and the law is clear. But let's also talk about what happens if Trump defies the order. If he does not produce the recordings in the next 9 days, and if the marshals take him into custody, what happens then? Legally, he would be held in a federal facility, not a prison, but a detention center. He would not be charged with a crime. He would simply be held until he complies. Now, his lawyers could file motions. They could argue that detention is unconstitutional. They could ask for a hearing. But all of that takes time, and while it's happening, he's still in custody. And here's the political reality. If Donald Trump is detained by order of the Supreme Court, that will dominate the news cycle in a way that nothing else could. It will be the only story, and it will force every political figure, every commentator, every voter to take a position. Do you support the rule of law, or do you support Trump? Because at that point, there's no middle ground. Now, some people will say this is persecution. They'll say it's a conspiracy. They'll say the deep state is trying to take him down. But here's the problem with that argument. This isn't the FBI. This isn't the DOJ. This isn't a prosecutor in Manhattan or Atlanta. This is the Supreme Court. And if you're arguing that the Supreme Court, including justices that Trump himself appointed, is part of a conspiracy against him, then you're arguing that the entire legal system is illegitimate. And that's a very dangerous place to be. Let me also say this. I'm not making accusations. I'm reading what's in the file. I'm telling you what the documents say, I'm telling you what the court has ordered, and I'm telling you what the consequences are if he doesn't comply. Now, here's what I think is going to happen. I think Trump's lawyers are going to file every motion they can think of in the next 9 days. I think they're going to argue that the recordings are privileged, that enforcement is unconstitutional, that the marshals don't have jurisdiction, that the whole thing is politically motivated. And I think the court is going to reject every single one of those arguments because they've already rejected them. That's why we're here. And then on the day the deadline expires, one of 2 things will happen. Either Trump will produce the recordings, or the marshals will take him into custody. There's no third option. The court has made that clear. Now, let me tell you why this matters beyond the immediate legal question. This is about whether a former president is above the law. It's about whether someone can simply refuse to comply with a court order because they don't like it. It's about whether the legal system can function when the person at the center of an investigation has the resources and the platform to turn every legal proceeding into a political circus. And it's about whether we as a country are willing to accept that there are 2 standards, one for the powerful and one for everyone else. Because if Trump can defy a Supreme Court order without consequence, then what's the point of having a legal system at all? Think about that. If you or I were served with a subpoena and we refused to comply, and a court ordered us to produce documents and we still refused, what would happen? We'd be held in contempt. We'd be fined. And if we kept refusing, we'd be detained. That's how the system works. There's no exception for being wealthy. There's no exception for being famous. And there's no exception for being a former president. This is a moment not just in Trump's legal battles, but in the history of this country, because what the Supreme Court does in the next 9 days will set a precedent that will last for generations. Either the rule of law applies to everyone, or it doesn't. And we're about to find out which one it is. Now, I want to go back to something I mentioned earlier, the two witnesses who testified under oath. We don't know their names, but we do know they had direct knowledge of the recordings, and we know they were willing to testify against Trump. That's significant, because in Trump's world, loyalty is everything. The fact that people who were close enough to him to know about these recordings are now cooperating with investigators tells you that the walls are closing in. And here's something else. The Solicitor General's letter references electronic records that corroborate the testimony. That means texts, emails, calendar entries, which means there are digital fingerprints all over this. And once information is digital, it's very hard to make it disappear. Even if Trump destroyed the recordings themselves, which there's no evidence he did, the government could still prove they existed through metadata, through witness testimony, through corroborating documents. So, the strategy of just refusing to hand them over doesn't actually work, because the government already knows what's on them. What they need is the recordings themselves to present to a jury. And Trump knows that, which is why he's fighting so hard to keep them hidden. Let me also point out that this isn't happening in a vacuum. There are multiple investigations happening simultaneously. Georgia, federal civil cases, defamation, fraud, and every time Trump is forced to produce evidence in one case, it has the potential to affect the others. So, if he hands over these recordings and they contain admissions or statements that are relevant to other cases, those recordings could be used against him in those cases too. That's why the stakes are so high. Now, some people are going to say, why now? Why is the Supreme Court acting now and not a year ago or 2 years ago? And the answer is because the legal process takes time. Subpoenas gets issued, they get challenged, cases get appealed, motions get filed, hearings get scheduled, and every step of the way, Trump's lawyers have fought to delay and obstruct. But eventually, you reach a point where the delays run out, and that's where we are now. The Supreme Court has said enough. No more delays, no more excuses. Comply or face detention. And that's not a bluff. So what happens next? Well, we wait. We wait to see if Trump produces the recordings. We wait to see if his lawyers file more motions. We wait to see if the marshals show up at Mar-a-Lago. And we wait to see if this country is willing to hold a former president accountable. But here's what you need to understand. This isn't just about Trump. This is about the principle that no one is above the law. Because if we lose that principle, we lose everything. We lose the idea that the legal system is fair. We lose the idea that justice is blind. We lose the idea that the rules apply to everyone equally. And once you lose that, you don't get it back. So this is a test, not just for Trump, not just for the Supreme Court, but for all of us. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does. This is history happening in real time, and you need to understand what's at stake.